Welcome back to Kivumbi 2017. Let's now take a look at what's making headlines on the dailies this morning. Like I mentioned earlier, on the front page there, making headlines today is that petition by the opposition NASA to the Supreme Court last night. On the front page of the Standard newspaper, what is in Raila's dossier? That dossier is 25,000 pages long. We'll be taking a look at that. On the front page of the Star newspaper, 3 options for Supreme Court in NASA petition. Well, in studio with us to help us make a sense of this legal jargon, we have lawyers Ashford Muriuki and Nelson Harvey. Gentlemen, many thanks for joining us on Kivumbi 2017. Let's first of all get your thoughts. If you were watching, because KTN News was live, I'm sure other stations were live as well, when the NASA principals were trying to beat that midnight deadline, and they arrived at the Supreme Court at about 11:35. That petition was later filed at about 11:42, just minutes away to the close of that deadline. Ashford, your thoughts on this, considering that they had ruled out the court option to begin with?
Well, Michelle, I think it must have been, of course, a lot of work for the team of lawyers who are preparing this petition. And 1 week really to prepare for a presidential petition, I don't think is sufficient time. So they must have really have gone an extra mile. That is probably what I think. But it may also be that the team was not properly organized, because when they announced that the court is not an option, well, probably, to my mind, I thought it could have been a strategy to probably tell the opposing parties that we are not going to court. But again, it could also be an indicator of disorganization within their team, that they didn't know actually which course of action to take. Right. So probably they may have made a decision after 1 or 2, 3 days that, okay, fine, let's go to court.
Have you 1 week to prepare for a presidential petition? In 2013, Raila's petition was 800 pages long. This particular petition, they say the affidavit is 25,000 pages long, and 90% of it, according to them, is evidence. Your thoughts on how that is likely to play out in this particular legal battle?
Now, in 2013, the Constitution was barely 2 years old. The Supreme Court itself was only 1 year old. No elaborate mechanisms had been set within which to submit and interrogate an election petition. No wonder, therefore, it is quite obvious that when faced with that petition, the case of Raila versus Uhuru in 2013, the Supreme Court adopted a more simplistic and technical approach of throwing out the entire evidence and making an almost theoretical and philosophical decision, as opposed to giving a justiciable decision. But with the passage of time and with much development in legislation, as well as many cases that have been filed recently to panel beat the manner in which the IBC is supposed to conduct the election, it's quite clear that with the passage of time, NASA and in particular Raila Odinga has been able to see the key areas within which to concentrate. Now that will explain why this time, unlike 2013, there is a voluminous record of evidence that supports his claim.
But of course, taking a look at page 4 of the paper, even as we go step by step, help us make sense of the legal procedure that the country will be facing. So the first procedure is the filing of a petition 7 days after the declaration of the presidential results. We saw the NASA leaders beat that deadline last night. Muriuki, what next for the country?
Well, what is going to happen is the Supreme Court is supposed to make a determination within 14 days after the filing of this petition. Now, we expect under the new rules that NASA coalition or Honorable Raila Odinga and his team of lawyers have to serve the other parties, the respondents, IBC and probably the President Kenyatta and his team, within 2 days. After that, the team will have 4 days in which to put in their reply, or what in layman's terms you can call defense. And I think after that there will be what we normally call pre-trial. and a day when the court is going to deal with what lawyers call interlocutory applications, which simply means housekeeping matters, you know, some urgent issues that have to be addressed before you go to the main hearing. And then after that, the judges will have to conduct the hearing. Yeah, so it is a one-week journey. To prepare all that, and then we can have a decision after the hearings take off.
Right. And of course, the period within which the Supreme Court will be making this ruling is 14 days. Let's take a look at the possible scenarios that the country has, Harvey, in terms of the Supreme Court and how it's likely to handle this particular petition. Analysts say there are 3 scenarios or 3 options that the Supreme Court has. What options are those?
Now, the responsibility of determining the validity of a presidential election rests on the Supreme Court under the Constitution. Now, much as analysts appear to have placed the options as 3, I think the Constitution is quite clear. The only avenue that the Supreme Court has to deal with this issue is to either validate the election of the president-elect or invalidate it. And in the event that it validates the election of the president-elect, then the inauguration and the swearing-in will take effect. In the event that it invalidates that election, then a fresh election will have to be conducted within 60 days. So in my humble opinion, therefore, there are only 2 options in the manner set out.
Let's take a look at the top of the page 4 and 5 of the standard here. And according to this, the first scenario will be that the petition filed could be dismissed by the court. Muriuki, perhaps even as we brainstorm on this, on what grounds could this possibility be actualized?
Well, what I expect to happen is the petitioner, who is Mr. Raila Odinga, and his team of lawyers, I expect that they have a good job. They have properly prepared and laid down good grounds, which must be supported by evidence that meets the necessary threshold to uphold that petition.
Right.
Now, in the event that that has not been met, that there are no clear, sufficient grounds in the petition with supporting evidence, then obviously, if that is the case, the court is going to dismiss the petition. Similarly, even if they have grounds in the petition, but there is no evidence to back it up, or evidence that is there is not admissible in court for one reason or another, again, that would be room for dismissal of the petition. But let me also add that because I think I have seen a lot of hype in the media about this, 25,000 pages, I don't know what number of pages. You know, I think we need to be very, very honest with ourselves when we are telling the public these things. What really matters is not how long that petition is. It does not matter what is contained in that 100,000 or 25,000. It's what are the concise grounds of that petition?
Right.
On what basis is Mr. Raila Odinga asking? Or claiming that either the elections, the votes were stolen and all that. Secondly, what evidence is there to prove those allegations? Thirdly, because I think my friend here will tell you, the law expects that there may be some malpractices here and there. And if it is alleged there was malpractice or hacking or whatever it is called, then election laws demand that whatever is proved must be of such magnitude that it substantially and significantly alters the ultimate result of the election.
Now, hold that thought there, because according to this particular dossier, NASA has argued that there were anomalies in more than 5,000 forms of 34A, which account for more than 1 million votes and would reduce the threshold of President Uhuru Kenyatta's victory to below 50% plus 1 of the required vote. Is this, if this is part of the evidence that is contained in that 25,000-page dossier, do you think it could hold water?
Now, when it comes to that issue of mathematics, if you're talking about the mathematics, how the votes were counted and all that, what I know for sure is that even in the lower courts, before even talk about the Supreme Court, for a party to be able to get really an order even for recount of votes subsequent to an election is not an easy task. There must be very, very strong and compelling evidence that you have to ask the courts. Actually, you are saying in layman's terms, convert yourself. to a polling center, to a tallying center, to a counting, to a returning officer. So you must have compelling evidence to show the court that these are very serious irregularities. This is what happened in blah, blah, blah. And it has been very glaring for you to get that kind of a recount. And it has to be demonstrated in no uncertain terms that a petitioner is entitled to a recount of those votes. But it's not automatic that you will just stand in court and tell the court, we want you to do a recount.
All right.
No, it is...
All right. Let's hear from you and some of the contents contained in this dossier by NASA, and among them, of course, is that those anomalies they say in the Form 34A, which would account for more than 1 million votes, and that would, significantly reduce the number of votes that President Uhuru Kenyatta got. But those also argue that by going to the Supreme Court, NASA is opening another avenue from the Freedom of Information Act, so that they may be able to obtain several crucial information that IEBC used in this election. Give us a bit more analysis on that.
Now, the election of the president is always conducted in 290 constituencies. Now, the threshold set out in the Constitution is that whatever method of election is adopted, it must be accurate and verifiable. Now, the main pillars upon which an election is conducted and upon which it may be challenged is best one, on the vote itself, and 2, on the count, and 3, on the tally. Now, if you interrogate the requirements for success for one to be declared the winner of a presidential election, he is required to have 50% plus 1. Ideally, he's also required to have more than 25% out of a half of the 47 counties. Now, if you look at the margin that appears to be between President Uhuru Kenyatta and Raila Odinga, it's in the region of almost 1.5 million. That's a very big margin. Now, these are the circumstances under which the petition against this election has been filed. Now, there has been a claim that there are so many polling stations that were not gazetted. Now, just from the threshold of it, that is a big dent on the first pillar, the voting itself. Because if these polling stations are not within the parameters set out within the law, then on what basis were the votes from those areas tallied? Then we go to the counting itself. We've seen on TV and even in the social media several instances of peculiar ways in which this count is being undertaken, so that you find in a situation whereby somebody is counting from 70 to 90, and then all of a sudden from 90 is jumping to 300. Again, these are some of the malpractices that have been pointed out. And then when it comes to the tallying, the Court of Appeal had made a decision that the finality of these results is as indicated by the record of the constituency returning officer. But again, that is not what happened during the process of transmission. It tended to appear as if the results were coming straight from the polling station to the National Tallying Center, as opposed to what the requirements stipulated, that they must be collected and tallied at the constituency level. Again, now that constitutes the third limb of this claim. And then, of course, there are other claims that zero around these three main arguments concerning the fidelity of the entire process. Yesterday, I heard Honorable Senator Orengo indicate that the ICT director had, in his last words, demonstrated the fidelity of this exercise, how impenetrable it was. And I think much as the petitioner, in this case, Raila Odinga, may not find sufficient comfort in the claim of hacking, in the claim of alteration, the moment they are able to demonstrate that for a fact, if you interrogate these three pillars, this election appears to have been a sham, then without even delving onto the impact that that sham has on the final result, the court is obligated under the law to say that there was no election at all. And then you move to the second category. If the court is to interrogate the effect of this non-compliance with the law on the general outcome, then it will be the obligation of Raila Odinga to demonstrate that these deficiencies have affected a number of votes, let's say between 500,000 up to 1.5 million. And to that extent, it cannot be demonstrated that President-elect garnered 50% plus one or was able to attain 25% of half of the 47 counties. And if that is proven, then the court may come to the conclusion invalidating the election.
All right, and that then would mean a rerun possibly for the country, something that we'll be exploring a bit later. But let's go back to NASA's first reaction, and that is we will not go to the court. And then they came back and had a change of heart. Raila Odinga, they're saying their change of heart was in a bid to offer the Supreme Court a second chance to redeem themselves. As legal practitioners, Muriuki, what stakes does this hold for the Supreme Court?
Well, Michelle, for me, I will tell you straight away that there is no, I have not seen any basis for any party trying to condemn or sort of make an attack on either the Supreme Court or any part of the judiciary.
I mean, this is Raila Odinga also drawing from his 2013 experience,
yes,
of course.
I don't agree with Mr. Raila Odinga, even with the way the matter was handled in 2013, because what happened was very clear. That certain documents which are claimed to have been evidence, 900 pages or whatever, we have never seen, we don't know. But it was alleged that it was evidence and was strong. But it was filed either out of time or without following the right procedures. Now, that, you know, in every game, Michelle, there are rules. You must play by the rules. It cannot be that every time you lose in a process, then that process is not credible. The Supreme Court is bound to apply the law and evidence. And I think it was not fair, and with a lot of humility, I must say this, it was not fair to the Supreme Court for a party who is filing a petition to sort of say, I am giving you a chance to redeem yourself. I really don't see any dent on our Supreme Court. What I would have expected is that with a lot of humility, any party dissatisfied with the election, file your petition, present your evidence, and argue your case. And if you allow me, I'll probably just comment that I know that the petitioner has been involved in these courts, in the judiciary, in various issues. I think the last decision was the most controversial of famous decision about the finality of the results at the constituency centers. What I know is my colleague Maina Kiai and others, and I think Mr. Senior Counsel James Orengo, were in that matter. And they are the ones who filed the application, the case before the court, and they were asking that the court do declare that results announced at the polling, at the returnees, at the constituencies are final. That decision was made by both the High Court and the Court of Appeal. Now, that is the petitioner in this particular Supreme petition is a beneficiary, a big beneficiary of that decision. And you find that the problem we had, I think, that has led to this petition, I think, in my view, that judgment in itself has caused us a big problem during the tallying and counting of these votes, because NASA and the team were able to obtain that judgment, saying that whatever results that are announced at the constituencies are final and cannot be changed. And you find that the effect of that judgment, in my view, was actually to deprive the IEBC and its commissioners of the power to make any alterations, whether mathematical or errors, whether by design or default, to the results which are tallied from the returning from the constituencies, polling centers, to the IEBC. So to the extent that even if you are going to raise issues at Boma Sterling Center and say, hey, look here, I'm supposed to have gotten 500,000 votes here, but my friend, Mr. Harvey, the returning officer, has indicated that I got 200,000 votes. There is nothing the IBC could do, the chairman or any of the commissioners, by virtue of that decision from the High Court and Court of Appeal. So you find you cannot have your own cake and eat it. You either have confidence in this judiciary or you don't.
Or you don't. All
so
right.
that is my view.
All right.
Yeah.
Harvey, the Supreme Court has been put on the spotlight here. Of course, all focus now shifts to the Supreme Court. Where do you think this leaves them in terms of the stakes for them in this particular petition?
Well, the fact that we didn't have a mobile phone 40 years ago does not mean that the world was foolish. It only means that the world has grown. And to the same extent, the judicial process also is alive to growth. In 2013, as I've indicated much earlier, the Supreme Court did not have any strong foundations upon which to make a credible decision. And I think we need to be candid on this point. The majority of the lawyers in this country have come to the conclusion that the decision in 2013 in Raila Odinga versus Uhuru Kenyatta was a bad decision. But with the passage of time, the Supreme Court has been able to redeem itself. Now, two decisions that come in mind are the cases of Joho and Shabal, where the cases of Joho and Shabal, as well as the case of Steve Kariuki versus George Wanjohi, where the foundation as regards the finality of the results at the constituency level was laid. Now, if you interrogate the manner in which the Supreme Court has eventually progressed in the handling of disputes, it seems to suggest that they are now taking a purposeful view. They're taking a more substantive view to ensuring that justice is done. And in fact, in the recent past, the Supreme Court has been very lenient, allowing as much as possible room for the litigants to submit all their evidence. But that does not mean that this is what will happen at this particular point in time. There are time frames within which the Supreme Court will have to consider this petition. But nonetheless, it is my humble view that this badge that a majority or a portion of Kenyans always put on the shoulder of Raila Odinga as being the perennial loser amounts to vilification, because it must be understood Raila commands a very big following. It cannot be that this is always a quest and a failure on the part of Raila. And it is my humble view that when you categorize the manner in which this argument has been progressed, it comes out quite clear that there is a percentage of Kenyans who stand for progression, and there is another group of Kenyans who stand for the status quo. And it cannot be said that what Raila is pursuing right now is a personal gain. We need to go back a little bit in history and see where were we before the Supreme Court. The two famous cases of Matiba versus Moi and Kibaki versus Moi are the foundation upon which the need to create a Supreme Court arose during the deliberations towards the promulgation of the new constitution. Because the entire country did not have faith in the High Court, did not have faith in the Court of Appeal as a result of these several decisions I've indicated. And it is therefore quite in order for the general public or for any litigant who appears before this court to indicate, look, last time you handled this matter in a manner that was not really in accordance with the law. With the growth of the systems that have been in place, it is our expectation that the matter be handled properly. And look, when IEBC started the process of preparation for this election, there were so many errors which unfolded both in public and even in the courts of law. And it's quite clear the election appears to have been bungled up to a percentage of 50%. Now, the only arbiter who has the final say on whether or not this election was conducted properly, or even if it was conducted properly, what are the areas of reform that need to be taken into account. And to that extent, it behooves the Supreme Court to rise above the position that it could have taken in 2013 and ensure that justice is served, not just for this particular litigant, not just for this particular moment, but for posterity. Otherwise, we'll be drawn back in the circle that we were about 20, 30 years ago, where we have the decisions in the manner of Matiba versus Moi or Kibaki versus Moi. And then that will have eroded all the gains made towards ensuring that the will of the people is continuously upheld on the ballot, and not through the whims of a group of individuals who may want to control the affairs of government.
And let's focus on how important that decision of by the Supreme Court may be. Taking a look at page 6 of the Standard this morning, standoff could run into 2018. So the headline here is, if the Supreme Court ordered fresh polls and the results of that poll are again contested in court, Kenya may find itself in a perpetual elections mode and get its president in 2018. And that same page also brings in the issue of the constitution of the bench. It is a 7-judge bench, of course. Talk to us about the stakes or the procedure of this ruling, because I understand that if a majority of the bench, and that is at least 4 out of 7 judges, rule against the petition by NASA, then that marks the end of the process for the opposition, NASA. Ashford, in terms of the constitution of this bench, and of course the new rules by the Supreme Court to ensure that they adhere by that 14-day deadline, how is it expected to work?
Well, I expect that the Supreme Court is going to be properly constituted. As in accordance with the Constitution, if you have 5 judges, that constitutes a quorum, but I understand, I think under the new rules, they are saying that we are going to have a full bench. And if all the parties play by the rules and comply with the timelines, I don't expect expect that there should be a problem. I expect that these judges are up to the task, and we should be able to get a decision within 14 days.
Right.
After all, there is, as my friend said here, we are anticipating probably either a decision determining that this election of the President Kenyatta is invalid, in which case we go to another election, or it is upheld.
Upheld, and then that, of course, would pave way for the swearing in of President Uhuru Kenyatta.
Yes.
Harvey, I know Muriuki tells us not to make a big deal of these 25,000 pages, but the Supreme Court has only 14 days. We're looking at 25,000 pages, and the window is still open for more people to enjoin themselves in this case. Is it sufficient time, in your view, for the Supreme Court to properly, justifiably review this evidence by the opposition?
14 days is sufficient time, bearing in mind that the hearing of this election petition before the Supreme Court will be based on affidavit evidence only. There will be no witnesses who will be called to the witness box to testify and be cross-examined. Much as the Supreme Court rules seems to suggest that a witness can be called to testify and be cross-examined, the new Supreme Court presidential election petition rules have now been streamlined, making it quite easy for the court to hear the entire petition within the period. I mean, ideally, they only have 7 days because the pre-trial compliance period is 7 days, then leaving the court with another 7 days. But we have seen in the recent past examples from the High Court and the Court of Appeal that justice can still be administered within a short period of time and substantively for that purpose. We saw in the case of Al Ghuraya, it was heard by the High Court for a period of 2 to 3 days, and within 2 days, the High Court was able to give a determination. And if you read the determination, irrespective of the fact that it ended up in the Court of Appeal, it is still well-reasoned. Now, when the matter went to the Court of Appeal, again, it was heard in a record 1 day, and in a record 2 days, a decision was given. The Supreme Court is not burdened by many other responsibilities as compared to the High Court and the Court of Appeal. Ideally, this is the fundamental function for which it was created. And if you take into account the threshold set out under the law, in respect of which the petitioner has to prove this case, it doesn't really become a confounding issue. It is quite easy for the judges of the Supreme Court to hear this matter and make a determination within those 14 days. It must also be understood that they need not give the entire reasoned decision within the 14 days. What they can do, they can give a summary, being a determination, either saying that we have allowed this petition, and for that reason, let there be a fresh election. Or we have dismissed this petition, and then let the consequential process follow. And then thereafter, they'll have a period of 21 days within which now to give the reasoned decision, which, bearing in mind the magnitude of the evidence that appears to have been submitted to the court, may require a ruling or a judgment that will go into hundreds of pages.
All right, let's take a look at page 7 of the paper. Still focusing on the Supreme Court there. The actors in this case are the same actors were in the 2013 presidential petition. And what's interesting is that these parties in the presidential election petition are likely to hire the same team of lawyers, while the Supreme Court has the same judges, save for 3 new faces. And of course, this raises questions on how different could this really go if the players in this legal petition are the same players that were in the 2013 case. Muriuki, do you think this particular lineup of lawyers and judges is any indication of how this case might go?
Well, Michelle, I think we have to tell Kenyans. I think I've been seeing a lot of this in the press, in the media. Like we are reading too much about who is the judge, who is the lawyer, and what have you. I think that is it is very bad culture. The judiciary operates on the basis of law, evidence, and professionalism. Now, to me, it doesn't really matter who is in the lineup in the team of lawyers. As long as they are professional, they are people who are competent, and I believe all of them are competent. I know them, and they are also on both sides. Both teams, the petitioner and the respondents, they have a good team of lawyers. And the judges are also they're professional, they are respected people. I don't think we really need to worry about really who's the team, who is the judge.
Because just before the election and the many court cases we saw IBC and NASA engage in, there was an issue of the sort that came up that, one of these judges is related to so-and-so in the opposition. This particular judge is related to so-and-so in the Jubilee Party. Maybe just to come to you, Harvey, do you think that this is something that will hold any water if it arises in this petition?
Now, under the Constitution, the Supreme Court is constituted by a bench of 7. And if you compare it to the High Court and the Court of Appeal, there is really no room to forum shop or to seek the disqualification of a judge on account of bias or any other reason. So to that extent, the bickering we had in respect of matters before the High Court and the Court of Appeal will not play here. And the Supreme Court has, in numerous occasions, had opportunity to consider this issue and said because of the peculiar nature of the function of this court, we will not entertain applications of disqualification on account of bias for one reason or the other. But permit me to address one issue. There is this perception that judges cannot be profiled, they cannot be considered on account of on how they are likely to rule. I think that's a big misconception. The Supreme Court is the apex court. And the manner in which it was designed, it was supposed to be a policy, public-oriented decision-making organ that is not encumbered by parochial issues. They're supposed to be able to move with the trend. And to that extent, worldwide, Supreme Court judges have been chosen on account of their accomplishment in their respective fields, on the account of their affiliations. Now, if you take that into account, you'll permit me now to say, you can say this is the ideology of this judge. This is the judge who prefers to theorize the issues. This is the judge who will go straight to the merits of the issues. This is the judge who has a leaning towards a conservative approach. This is a judge who was leaning towards a progressive approach. And I think it is very important on the part of the lawyers appearing before this judge to do a background check and interrogate. If at all Raila Odinga's case is there is massive malpractices, which is evidenced by the documents we presented before the court, then it will be incumbent upon them to plow and make good use of those judges who are known to go straight to the point. And then if somebody else, let's say perhaps the lawyers for IBC or the lawyers for President Uhuru Kenyatta, want to espouse a theory that despite all these problems you have seen, you don't need to interfere with the status quo, then they will have a leaning towards those judges that appear to be very philosophical, who use a lot of terminology to circumvent or to navigate an issue and explain it. So to that extent, I think it's proper to make a review of who this judge is. And for instance, I mean, if a judge has a particular leaning towards a certain ideology, it will be foolhardy not to anticipate the manner in which the judge is likely to rule. And that is in order. But it doesn't mean the litigants or the public should start a debate of saying, okay, fine, this judge appears to come from Mount Kenya, this judge appears to come from Rift Valley, the other one's from Lake Victoria. No, I think that is very unfair, it's very oppressive. A judge is first a lawyer and second a judge. So it is a presumption that irrespective of his affiliations, and take into consideration one important factor. You saw on TV Justice Maraga voting. So all these judges voted. So they have their own preferences. But when it comes to considering the law, they have the fidelity to separate themselves from their own personal lives and take into account that what they are doing is a national duty, is a duty to do justice, to uphold the law. And in my humble view, it is not a big problem for a judge to do that.
All right, and I want us to finalize on this petition. And on page 8 of the paper, we have Kichumba Mirkomen here on the opinion segment saying Raila should be ready to accept the Supreme Court verdict on the case. I mean, Muriuki, is there any other option? We've already laid out the options that the Supreme Court has. It is either nullifying this petition or going ahead with this petition. But is there any option? Because the very statement that they do not trust the court, which was an initial statement by the opposition, was regarded as a thinly veiled attack on the Supreme Court and on the judiciary. Should this particular verdict not be in their favor, is there any other option for the opposition?
No. To be very honest, there is no other legal or constitutional option known to me or known to Kenyan law other than the decision that is going to come out of the Supreme Court. So if the court dismisses that petition, very unfortunately, but they have to be, they have to have the humility and courage at the same time to accept and respect the decision. If it goes the other way and the petition is allowed, also the president and his team must also have the humility and the courage to accept that verdict. There cannot be, and I don't see any other option because we are not going to say that let people go to the streets or to the bush. And no, we cannot. I don't even want to think that way myself. I think if we have to build this country, we must we must all believe in the rule of law. We must all believe in the institutions that we have. We must all believe in the systems, because if we are going to go outside the Constitution, or if you are going to say, let us give certain provisions of the Constitution an interpretation that gives us some other options that really, truly are not known to law or are not legal. I think that is not fair. I think it is important that whatever decision comes out of this court process is respected by all. Parties may not accept it, but at least they must be able to respect it and live by it.
All right. Yes. Let's take a look at what else is making headlines on the dailies. Of course, we'll be keeping an eye on that, on how this legal battle ensues. But on page 10 of the paper, tears as Msando's body arrives home. And this is the body of the slain IBC ICT manager, Chris Msando, who is said to be laid to rest today. Even as the family continues to call for justice, they have been asking what happened to the calls or the offer by the UK and the US to help find the killers of Msando. But Msando's death also raises questions as to many other mysterious deaths of either high-profile people very crucial, in the electoral process, just days or weeks to the to the day of the election. And let's begin with you, Javi, in terms of the credibility, or what Kenyans are waiting for in terms of communication as to Msando's killers, because the last thing Kenyans heard is investigations are underway and no stone will be left unturned. But it's the same thing we heard about the likes of Tom Mboya and Robert Oko.
Now, this is a very sad set of events. My friend Apollo Mboya has originated a claim in the High Court to compel the president to set up a commission of inquiry to investigate and with finality deal with this issue of mysterious deaths, which more often than not are blamed on the government. And truth be told, the responsibility of ensuring the security of an individual is the responsibility of the government. If you look at several cases of homicide, where for a fact no accusing finger has been pointed towards the government, it is very easy to apprehend and bring these individuals to book. But in some of these cases where a pointing finger is targeted toward the government or certain rogue elements, I do not say that it is the government that could have been responsible, but there could be some rogue individuals using the state machinery to occasion these things. It's always very difficult to come to the bottom of it.
Right.
Now, and in this particular case, we've been told that the last testimony and words of the late Msando will form part of the evidence in this election petition of Raila versus Uhuru Kenyatta. So it remains to be seen to what extent, if at all, his death is to be related to this election. But I think it is a high time that the court that will be considering this case by Apollo Mboya makes progress in ensuring that these things do not happen again. In developed democracies like in the United States, you're able to see the exercise of the freedoms and rights enjoyed under the Bill of Rights without intrusion, without curtailment of the liberty or threats to the person, or even death of those who are perceived to have either acted or omitted to act in a manner that the state may have wanted things to go.
All right. Ashford, maybe your thoughts are the same, because there are those who say, you know, with every election period comes issues like this. Many are meant to, you know, cause controversy, divert attention from other crucial issues. But your thoughts on the death of Chris Msando? It raised a lot of eyebrows, of course, also casting aspersions on the credibility of the electoral process as well.
Yes, this is, of course, very, very sad, very, very sad, and it's not just unfortunate, it's very, very sad. It shouldn't happen, and these mysterious deaths, I think, are becoming too much in this country. I hope, and I hope that, as the government has been saying, that the relevant authorities are able to get to the bottom of the matter. We need to know why, how, who, I know all those four, the W's, the who, the why, what, why this Chris had to die in this manner. And I think beyond that, as my colleague has said, there needs to be a way of putting a check or to get these mysterious in-court killings that have been taking place in this country, they need to come to an end.
Right. I
think we are losing too many people, we are losing families, we are losing friends, brothers, sisters, husbands, what have you. And sometimes, like in the case of Chris, probably now until the burial is tomorrow, people have been talking about it, and then after some time, it's all forgotten. And, you know, it just becomes another part of our history and life moves on. I think that needs to stop. We need to really find a way of having to get to the bottom of issues like this.
Right,
so
right.
The killers have to
be found. Of course, that's what the country is waiting for. That's what's making headlines on the dailies this morning. Do grab your copy of the Star newspaper, the Standard newspaper, as well as the Daily Nation for those and more stories. But gentlemen, just before we take a break, one more issue that has been making headlines this week is the fact that the 2/3 gender rule act has gone back to court, and we have civil society organizations there which are seeking, of course, to stop the first sitting of the 12th Parliament, which is meant in about 2 weeks' time, because it does not meet the criteria set out in the Constitution. Harvey, this is something that has been elusive for the country for quite a long time. What implications does it pose for the 12th Parliament?
As the 12th Parliament is set to begin its business, it has an encumbrance on its shoulder. There is already a decision that was made by the High Court directing the implementation of the 2/3 gender rule, failing which any aggrieved party will petition the Chief Justice to advise the President to dissolve the Parliament. In actual fact, by the time we're going to the election, the Parliament was illegally constituted because it did not comply, and it was subject to dissolution. Now, the incoming Parliament still suffers the same problem, and it is probable that that will be the first bottleneck. And if advice is to be sought, then I think as day succeeds night, if there is a challenge to the constitution of this Parliament on account of that fact, it is a challenge that will succeed. And it's most likely that the President will be called upon to dissolve this Parliament in order that we go to a fresh election and the Parliament is properly constituted. But I think our sisters and mothers must also have some measure of blame. Michelle, I think it would have been a good idea if most of you submitted yourself for elective office, because it will be asked, yes, this is what the law says, but we have a situation whereby, despite what the law says, we've not seen any candidates from the female gender submitting their names here. So how are we supposed to have compliance? Look at like the case of the recruitment of judges of the Supreme Court that happened last year. There was a big query. Why was it not representative to take into account the requirements of a 2/3 gender rule? And you see, that is a malaise that saddles the current Supreme Court also. And then in explanation, the Judicial Service Commission said, of course, we gave out the invitation, but we didn't see any qualifying candidates from the female gender. Now, if this is to happen, and if it's bound to happen soon, then we'll have a continuous case of interruption, because the law says in the event that the two-thirds gender rule is not complied with within that time, then there will be continuous dissolutions, And I think this will be a big disruption. Perhaps what may need to be taken into account this time is to ensure that there is sufficient mobilization in the two houses to ensure that the legislation that is intended to actualize this two-thirds gender rule comes into force. Because remember, there were several attempts by the latter parliament to do this, and it never reached fruition.
Right.
So maybe it may be quite important for this parliament to undertake as its first order of business to ensure that there is legislation. For instance, parties can be compelled to ensure that when they're submitting their names for nominees, when they are submitting the names,
the list of aspirants.
Yes, the list of aspirants. It complies with the two-thirds.
And that was the next question, because I mean, whose onus is this? On one hand, yes, more women need to come and front themselves in these positions, but can we take the political parties into account? Because you know, they can ensure that they have a two-thirds gender rule in their list of aspirants, and then there's also the Register of Political Parties, who obviously very willingly passed this list of aspirants by all the political parties without them having achieved the two-thirds gender rule. Then we have the Independent Electoral and Boundaries Commission, which again also has access to the list of aspirants from different parties. So whose onus is it? And isn't it meant to be a multi-sectoral approach as you know, we try to implement this two-thirds gender rule? Muriuki.
I agree with you entirely that with regard to this issue of the two-thirds gender rule, actually the biggest problem and the big question is whose responsibility is it? And it's a perfect example of what I usually call what really are the social foundations of this law on two-thirds gender rule. You know, the minute you have a law that has got either no social foundation or SFL, or doesn't have a sound basis, and social foundation in this case refers to it must be able to really work well and fit within the society. Now, in this particular case of the two-thirds gender rule, you have a problem because you are not really able to pinpoint for a fact whose legal obligation or what obligation is it to make sure that this really happens. Is it which organ of the state? Is it the president? Is it which institution? Is it the society? So that's why you have that kind of a problem. And I think the only way that this has to be done is that, one, people have to be realistic to see the best way possible in which it can be achieved. If it is taking the political parties route, then we can be able to see whether we can input some sort of conditions on these political parties when they are putting names forward for either nominations or whatever to comply with this rule. Or if it is the Electoral Commission, tell them, okay, you do not accept either nominations or list of persons if you don't comply with this rule. But to be very, very practical, because I am a believer in the so-called social foundation of law. If you say that because of the two-thirds gender rule, then we paralyze parliament or we dissolve parliament, to me that is not the route to go.
Right.
Because I don't believe, I think is it law was made for man or man was made for the law? I think it is the other way around. So we cannot say that because we have not achieved this two-thirds gender rule. Remember, it is not just about women. It is about both gender.
Right.
So it can be either way. So we cannot say after going through all this kind of a very expensive, very long election that now we are not able to achieve, then the best we can do now is to hold the country at ransom by saying we cannot inaugurate this parliament.
But then why did we pass this constitution and we keep asking for more laws to ensure that you know, the political parties and the IBC and the Register of Political Parties actually adhere by the law? Do we really need more laws in place? And shouldn't all these institutions be guided by that same constitution?
You know, Michelle, there's a point I was trying to make here. That actually one problem we have in this country, Kenya, is not the problem that we don't have the law. We just have too much of it. Too much law.
Right.
That is one of our biggest problems. It has never been a shortage or lack of it. Now, you also have instances like now, in the case of this two-thirds gender rule, the question is, one, how practical is it? We must be very honest with ourselves. How practical is it that we have to be able to ensure that from every institution of this society, whether it is parliament, whether it is IBC, whether it is the court, is it really possible and practical that we will be able to achieve this, to make sure that we do not breach that issue of gender rule? You will find that in most cases, it is not easy, and sometimes it's even impossible. And that's why I agree that, as my friend has said, if it is the women, like in the particular case now, we have not been able to achieve the number of women that we need in all these institutions. Right. There is a way. We have to encourage them. You have to come out. You have to apply for these positions. You have to be confident and actually fight for these positions. Because you can see, like, we have a problem. The other day I listened to Dr. Joyce Laboso, I think, on your show. I don't know which one. And she was saying, now we have just the first 3 women governors. Now, the problem, in her view, is how are you going to handle this issue of even this 2/3 gender rule? And she was saying that if this parliament that we are going to have is going to be another male-dominated parliament, and we are trying to comply with this law, we are still going to have a problem. So we need to find a way of having either a progressive way of doing it, and in a manner that... Which is
what the court decided 5 years ago.
Yes. But the problem is, as I've told you, sometimes you have a law that is almost impractical to implement.
All right.
So it is let me just call it, it's problematic. It's problematic. And all of us have a responsibility to deal with it.
Let's hear from Harvey.
Yes.
Is this impractical, as Muruki seems to ask, because many times we hear we have not achieved the 2/3 gender rule because there is lack of goodwill from the political stakeholders. Is this an impractical law to pass in our country?
Let me be philosophical on these things. Good men do not need laws to do right things. And bad men will always do wrong things within the law. Now, the reason as to why this 2/3 gender rule came into place was to secure the rights of the girl child for now and for posterity. Because if you look at the manner in which the parliament has inherited from the white man was formulated, it was male-dominated. And the laws that were passed tended to favor the man. So the truth of this matter is the 2/3 gender rule was intended to ensure that the female gender is given an equal opportunity, both in appointive or even elective office. And you can see the mischief that the 11th Parliament dealt with on this issue. Because, of course, the law was there, but they circumvented through the law, and curiously, with the participation of most of the female members of parliament, because the totality of it is, whereas there was a law, I think these people were just keen on ensuring that they don't do anything right in respect of that law. But to close this thing, it's not that there is a handicap on what has to be done. The court has made it quite clear. The Attorney General, through the National Assembly, is supposed to put in place legislation so that it's not that the registrar of political parties, the IBC, or the parties themselves are handicapped. The handicap is there is no law upon which to panel beat them. So that let the 12th Parliament commence its business with this primordial assignment, put in place a legal mechanism. If that mechanism is in place, then we'll resile to the plateau position. We have the law. The good men have decided to do bad things within the law. And if, the bad men have decided to do bad things within the law. And if the good men decide to do good things irrespective of whether it is in the law or it's not there, then we'll have a flourishing society. And I think that is the most important consideration, that the people who elected these individuals should implore them to take into account as they commence their business in the 12th Parliament.
Let's focus on how much water this case is already in court. The petition has already been made, has already been filed in court. Let's talk about how much water either decision the court makes will hold on Parliament as a whole. Muriuki.
Well, either way, whatever decision that comes out of the court case, obviously it holds water. Depending, I don't know what decision is going to be made, but ultimately it has to be a decision or a judgment that helps
helps. I mean, what options are there? Because 5 years ago, the court said it should be a progressive implementation, and we haven't seen any substantial, changes that have been seen since then.
Well, I think the best route to take would be to put in place the legislation my friend Nelson here is talking about. And again, we have to do a lot of consultation within all the stakeholders involved in the society on this issue. Because again, you need the goodwill. If you say that the men in parliament are always opposed to this, we need to find a way of engaging them. We need to find a way of also getting the goodwill from every other stakeholder, so that if we have to put in the necessary legal framework that can help to operationalize that particular clause in the Constitution, then things are going to work out. But I don't think that adopting what I might call a confrontational approach is going to be the best way forward.
Right. Yes, and of course, as we wind up having...
we don't want to put our courts in a situation where that they are forced to make decisions that cannot be implemented or that are in vain, because again, then that will embarrass the court. You can't have the judgments being delivered today, tomorrow, but at the practical level, it is not possible to achieve that. So we need to also be very candid with the court and find a way that a decision is made that is going to be, can be implemented, and that we can see the results. Yeah.
And that's an interesting order, considering the Supreme Court will also be reading from the same constitution. But Harvey, where does this leave the fate of the 12th Parliament, which is expected to have its first sitting in about 2 weeks' time?
Well, Parliament will be prorogued and it will sit despite that deficiency. It will sit, but as I've indicated, then it will be a core responsibility, because as Ashford has said, the court has made a decision, and then we have a situation whereby there's been non-compliance. It's incapable of compliance, not because of mischief, intent, or neglect, but because of the circumstances in which we found ourselves. And then on that, I think we need to remind Kenyans always suffer short-term memory loss. The reason as to why there has to be a lot of vigilance. The moment you've elected your leaders to go to parliament, don't leave it at that. Make a follow-up. This thing we call public participation is intended to enable the electorate check on those leaders who are either elected or appointed to ensure that they are doing the right thing. Because if you don't do this, it will only come to pass after 5 years that this is what they were required to do and they haven't done it. Then it will be us. Look, you are the employer of these people. What did you do to ensure that they do exactly what they've been contracted to perform? Therefore, it is my humble view that vigilance is very important on the part of the executive, on the part of the judiciary, and on the part of the legislature. Because people need to understand that this constitution was intended to be for the people, so that the people will have an opportunity to pyramid all their requests, so that as the legislature, as the executive, and the judiciary performs its core functions of government, they're able to confine themselves within the four fundamental bricks that found that pyramid. But if the people are not there to provide this foundation, you'll always have this lamentation time after time, and there'll be no fruition. And we'll end up having a situation whereby the Constitution is just
another book.
Another book.
Right. Thank you so much. That's a good point to end this conversation. Lawyers Nelson Harvey and Ashford Muriuki helping us make sense of some of the legal cases that are making headlines in the country. Top on the agenda is that petition by the opposition NASA, which was filed at the Supreme Court just before midnight last night, opening a legal battle for another presidential petition. These being the very same contenders that were in the 2013 presidential petition. And also another case making headlines is that two-thirds gender rule with civil society organizations now moving to court, seeking to bar the 12th Parliament from sitting for failure to abide by the two-thirds gender rule. Two stories we'll be keeping an eye on for you here on Kivumbi 2017. Thank you so much for watching the early edition with me, Michelle Ngele. We've come to a close for now. We take a short break, but do stay with us. Kivumbi 2017 continues in a few minutes.
This is KTN News.